Internal Revenue Service personnel have no authority to levy salaries and wages from privately owned companies. IRS authority is applicable solely to government agencies and personnel by 26 U.S.C. 6331. Levy may be made upon the accrued salary or wages of any officer, employee, or elected official of the United States, the District of Columbia, or any agency or instrumentality of the United States or the District of Columbia, serving a notice of levy on the employer. First, such notices must include a Form 668B, which is the actual levy. Second, only those large businesses and governmental units that have designated officers and written agreements are authorized to receive notices of levy by mail. Third, to complete the levy, another form, Form 668C, must be served, but cannot be served by mail. It must be served in person. That complete service of notice of levy. Absent Form 668B, there is no evidence that there is a levy. In the event the IRS fails to serve either or both the levy and Form 668C, service of process is incomplete and the IRS defaults. In brief, there can be no seizure before adjudgment in a state court is rendered. Further, the AGO Attorney General's Office states clearly that there are two forms of judicial process referred to above, writs of attachment and writs of garnishment. And since a notice of levy is neither, it should be obvious that it is not service of process in any legal sense whatsoever. Federal law says that a levy must be served with a writ of attachment. Writs of attachment have a different purpose than writs of garnishment. A levy is not a garnishment. A levy is an attachment. It takes a court action to compel anyone to surrender a consumer's property to another, such as the IRS collection agency, without the consumer's consent and over his objection. In sum, a notice of levy is not a levy nor a garnishment. Lawful status of the IRS. This chapter is presented to expose the criminal conduct of the IRS regarding the racketeering activity of interference with commerce, 18 U.S.C. 1951, extortionate credit transactions, 18 U.S.C. 891 to 890, and conspiracy against rights, 18 U.S.C. 241. The Internal Revenue Service has been informed of the law, but they refuse to comply by unlawfully imposing notices of levy on the private income of consumers without due process of law. The United States Code clearly establishes due process for collections, 26 U.S.C. 6330. The common practice of this organized crime is clear. One office of the IRS accepts payment in full. Then another office of the IRS levies against the property of that person and collects the debt yet again without any due process of law. Lawful status. The Internal Revenue Service is incorporated in Delaware as a collection agency for a Puerto Rico company titled Internal Revenue Tax and Audit Service IRS for Profit General Corporation I Incorporated. Date July 12, 1933. I file number 0325720. Therefore, the Internal Revenue Service must be recognized in its lawful status as a collection agency, not fraudulently accepted as a government agency. 125. Learn to play the game. This business corporation is accountable under Title 15 of the U.S.C. Section 1692E. A debt collector may not use false, deceptive, or misleading representation. It is a common misconception that the Internal Revenue Service is part of the United States government, but in fact, it is a private corporation. Through fraud, manipulation, conspiracy, deceit, and impersonation of law enforcement personnel, the IRS has become an organized crime syndicate operating illegally in every state of this union. There are three major elements of this organized crime as follows. 1. Extortionate credit transactions, 18 U.S.C. 891 to 894. This is the common practice of IRS agents to threaten, coerce, intimidate, and force the people to pay a debt that the IRS fabricates out of thin air and cannot lawfully establish. There is no due process of law allowed. Those who oppose the tax are prosecuted by U.S. attorneys who are more than willing to engage in conspiracy against rights, 18 U.S.C. 241, for the profits they receive from the money they extort within the fraud, 18 U.S.C. 1001, of claiming to collect a debt that is owed, whereas in fact, no debt to the IRS can be lawfully established. It cannot be lawfully established that an American citizen owes this corporation anything. All claims that they do are fraud. 2. Seizure of property without due process. Violation of Fourth Amendment. 126. Commercial law aned. It has become the common practice of the IRS to file levies against personal property without any judicial process. These levies are filed with the Recorder of Deeds, who has established the common practice of allowing levies of the IRS to be recorded without a judgment signed by the judge, lawfully required for the filing of a levy. 26 U.S.C. 6330. Later, the agent returns to the Recorder of Deeds and obtains a certified copy of the alleged lien that they present to the sheriff for seizure of the property. The sheriffs and deputies are duped into enforcing this bogus lien and violating the American citizen without due process of law in violation of the Fourth Amendment. It is the responsibility of every sheriff to not enforce any levy not supported by a judgment signed by a judge. Every sheriff has denied due process of law in every instance he has exercised a levy without judgment of the court. 3. Seizure of bank accounts, income without due process. Violation of Fourth Amendment. It has become the common practice of the IRS to seize bank accounts and income of the American citizens without any due process of law. As clearly evident by the attached letter, the IRS has taken $133.20 from David Anderson, who was not informed or given the right to respond, because he would have disputed the debt, because the debt has been paid in full. The IRS claims they have rights to property of private citizens and enforce those rights without judicial process, thus establishing organized crime for profit. Lawful challenge to the Secretary of the Treasury for the United States of America. As clearly indicated, the IRS is fraudulently operating under the designation of the Department of the 127. Treasury. As a corporation, the IRS cannot lawfully misrepresent itself to the public by declaring itself to be a part of the U.S. government. This act is prohibited by 15 U.S.C. 1692e, unless the Secretary of the Treasury for the United States of America is willing to state under penalty of perjury that he has given government authority to the IRS, a private for-profit corporation, and willing to accept accountability for all acts of illegal seizure by the corporation. The IRS is clearly engaged in conspiracy to defraud the public by leading the public to believe they are a part of the U.S. government. This deception is being supported by the U.S. Department of the Treasury, clearly shown in the attached letter, by this government acting on behalf of the IRS without any due process of law. Either the Secretary will confirm or deny the IRS's government status, and our representatives must take action accordingly. Our United States representatives are responsible to stop this organized crime and to date have remained silent. The people have the right of protection of law, and the systems being operated by the IRS are clearly a deprivation of due process of law. When criminals are engaged in organized crime and doing so under fraud,